Today we have Warren, who will be presenting on the topic of maritime insolvency law in Africa and under the UNCITRAL model law on cross-border insolvency. He will be unpacking the model law on whether it is a blessing or a curse to maritime insolvency in Africa. Surprisingly, when I was having a chat with Warren, this topic of maritime insolvency caught my eye, and I've been thinking there are so many areas of insolvency law that researchers and academics from the continent really haven't paid too much interest. I mean, we tend to look at personal insolvency and companies, corporate per se, but how about shipping companies? How about maritime insolvency law? And I was so much interested that I managed to get a copy of a book on maritime insolvency. Jin-Shun Zhou, who wrote a book on maritime cross-border insolvency under the UNCITRAL model law, which came out last year, and it is a beauty. I've read 3 chapters and I'm thinking, wow, this is a very good area of the law that maybe we ought to pay more attention to. So Warren is about to complete his PhD and also looking at the administration of maritime security interests in insolvency proceedings. And he's at Erasmus University in Rotterdam in Netherlands. And he's also been a junior lecturer at the same university. And he's also published several peer-reviewed articles. The list is really endless of his publications, which I can't read out. But as usual, we tend to publish the bio of the presenter, and I would really welcome you to have a look at his publications in the area and presentations, and maybe perhaps try to link up with him for further collaborative work on the topic. His discussant today will be Julia, who's a PhD holder in maritime insolvency law. She obtained her PhD from City University of London, and she has also lectured in the field of commercial and maritime law for many years at the University of Rotterdam, and also as an assistant professor and an academic coordinator of the LLM, commercial law and company law. And recently she moved back to Brazil, where she has set up her own consultancy firm and working and setting up courses on maritime insolvency law. So I welcome you all, and I hope it will be an interesting journey. And Warren, over to you. Thank you very much.
Thank you very much to you, Hamizi, for this very generous introduction. And thank you as well for inviting me, of course, here today to give a presentation. Let me try to share my screen, first of all. Okay, I guess you can all see the screen now. Great. So yeah, well, also from my part, good afternoon to everyone, and yeah, well, thanks once again, Hamizi, but also Bolande for this organizing and initiating this great initiative. I've been present at a couple of previous seminars, and I must say that I've already learned a lot of new stuff, and I'm really looking forward to at some point meet all of you and exchange ideas in person. So yeah, really looking forward to that, and keep up the good work, I would say. So yeah, as Hamizi has already introduced, today I will be talking about maritime insolvency in Africa. So well, to avoid all confusion, whenever I'm talking about maritime insolvency, I refer to insolvencies of shipping companies, of course, and perhaps even more specifically, cross-border insolvency of shipping companies, because, well, considering the international mobility of ships, an insolvency of a shipping company is almost by definition a cross-border insolvency of a shipping company. And the biggest issues in such insolvencies actually also play a role on the cross-border level rather than on the domestic level. So, well, the full title of my presentation is Maritime Insolvency in Africa, the UNCITRAL Model on Cross-Border Insolvency, Blessing or Curse. So as the title says itself, I will be evaluating how the UNCITRAL model law can play a role, how maritime security interests are administered in Africa under the UNCITRAL model law, and whether this is really the most appropriate and adequate instrument to do so. So here's a little overview of what I will be discussing today. So first of all, I will start with a little bit of context on maritime business in general, but also maritime business in Africa. Also maritime insolvency in general more, and then also more focused on, well, what is the impact of maritime insolvency in Africa, or how do maritime insolvencies play a role in African countries. Secondly, then I will focus more on a very specific and peculiar sort of maritime security interest called maritime lien, and I will take a look at how maritime liens are regulated in a couple of African jurisdictions. Then thirdly, I will turn to cross-border insolvency, focusing mostly, of course, on the difference between African countries that have enacted the UNCITRAL model law in their domestic legislation on the one hand, and African countries that have not enacted the UNCITRAL model law in their domestic legislation on the other. And then finally, before turning to the conclusion and hopefully a fruitful discussion, in the last part, I will then merge or bring the second and the third part together and look more closely how maritime liens are administered in cross-border insolvency in certain African countries which have enacted the model law or not, and evaluate a bit. Okay, so well, just to give a little bit of context here. So on the website of the OECD states that the oceans provide the main transport arteries for global trade. And if you look at the illustration on the right side of the slide, this is a depiction of a live depiction actually of the entire global fleet at some point yesterday morning. So you see that really the oceans are really the main transport arteries for global trade, as the OECD says. And in fact, more than 90% of goods worldwide at some point during their life cycle, at some point during their life cycle are transported overseas. So over 90% of the goods worldwide. So that's just enormous. And in fact, well, nowadays, indeed, maritime transport is so important for the global economy and for global trade. But this has actually been so throughout history and throughout the ages. And there is actually, well, the Latin quote on the slide is actually a quote that is still often used in shipping, and which loosely translates as, well, it is more important to sail than to live, even. So just to demonstrate how important maritime trade is not only now, but has actually been throughout history. The two other pictures on the side are also just an illustration of how important and how impactful maritime trade is on the entire global economy and on the daily lives of all of us. I think most of you will recognize the picture on the left side of the slide. That is the ship, the Ever Given, that well, the ship that was stranded in the Suez Canal and blocked the entire Suez Canal for a couple of days earlier this year, which illustrated how much of an impact actually maritime trade has on the entire global economy. The consequences of this blockage of the Suez Canal are still to be felt today even. And then the middle picture I like very much, because it actually also demonstrates how enormous of a business the maritime sector and shipping actually is. So the little tower that you see here next to the ship is actually the last addition to the skyline of Rotterdam. And it is actually also the largest tower in, or the highest tower in Rotterdam, the highest tower in the Netherlands, and even in the Benelux region of more than 200 meters. And next to it, you see the largest container ship, the Ever Ace, which is almost twice as high, as large as that tower. So it's almost 400 meters, 4 football fields long, and well, for the UK public here, almost 1 football field higher than the Shard in London. So this was just a little bit of general context on the maritime sector, but focusing now on the maritime business in Africa. So similarly as for other continents, almost 90% of import and export towards and from the continent are conducted by sea. So, well, most of the goods that arrive or leave the continent are transported by ocean vessels. But by contrast, however, we see that only 1% of the global fleet is African-owned. So you see that the African continent is a very strong trading partner for the rest of the world, but on the other hand, it doesn't really have a very strong ship-owning culture yet, perhaps. Because there are actually predictions that in the upcoming years and decades, that the portion of African-owned ships in the entire global fleet will increase substantially, especially taking into consideration the recent implementation or adoption of introduction of the African Continental Free Trade Area. It is predicted that this will really increase intra-African trade mostly, and as a result, this would then also increase the African fleet. So it remains to be seen, but for now, the African fleet is quite limited. But this is a bit the general, a general picture of maritime business in Africa, but there are also a couple of very specific maritime hubs within Africa. And most notably, or perhaps even most infamously, there is the Liberian Shipping Registry, which used to be the second largest shipping registry for a long time in the entire world, after Panama. But in recent years, the Liberian Ship Registry has been surpassed by the registry of the Marshall Islands, but it is still one of the largest ship registries in the entire world. In all fairness, the Liberian Ship Registry doesn't really have that much to do with Liberia as a country, but it's merely some sort of a vehicle for mostly American ship owners to register their ship, and at the same time also avoiding regulatory burdens in mostly the United States. So besides that, there are also the very specific offshore hubs of Nigeria and Angola, with all their very specific issues and problems, which will not really be the center of the presentation today. And then finally, there are also a couple of very important trade routes in Africa. You have, of course, the Cape route, but most notably as well, the Suez Canal in Egypt, which is a huge source of income for the Egyptian government. Last year, only more than 18,000 ships crossed the Suez Canal. So it is really the main trading routes from Europe to Asia, and well, mostly from Asia to Europe, actually. So the next point is the connectivity of African ports. So if you also look at the table on the right side of the slide, you see that the connectivity of African ports is mostly related to their geographical location. If you look at the best connected ports in Africa, you see that they are all located at the corners of the continent. So you have the Moroccan ports, Egyptian ports, South African ports, but also perhaps more surprisingly, ports in Djibouti and Togo. So according to statistics by UNCITRAL, these are the most connected regions in maritime regions in Africa. The next point, unfortunately, is the legacy of piracy on the continent. So, well, there has been a huge problem of piracy, most notably around the Horn of Africa, in front of the coast of Somalia, but also in West Africa. But in recent years, I must say that this problem has been under control and has been tackled by a concerted effort by both ship owners, the international community, but also the governments of Somalia and Nigeria, for example. But nevertheless, there remains some sort of a stigma of piracy. Well, we all know the Hollywood movie Captain Phillips, for instance. But if you also look at insurance policies, for instance, you see that premiums are still very high if your ship passes through, for instance, the Horn of Africa or Somali coasts. Finally, and this is also a bit of an outlook towards the future of maritime business in Africa, it remains to be seen what the impact will be of a couple of international initiatives on maritime business in Africa. The first initiative I already introduced earlier, so the African Continental Free Trade Area. So it remains to be seen how much this will improve intra-African trade, and as a result, whether or not, or to which extent the African fleet will increase. Another of such initiatives is the Chinese Belt and Road Initiative. China has invested considerably in a couple of ports in mostly East African ports, so it also remains to be seen how this will further impact maritime business in these countries. And then finally, of course, climate change and the decarbonization of maritime trade. Well, this is obviously a global problem, but the impact of this movement on maritime business in Africa remains to be seen. Okay, now focusing on maritime insolvency in Africa. So as I said, the proportion of African ships in the global fleet is quite limited. So as a result, there are also not that many, because there are not that many African shipping companies, there are also not that many African bankrupt shipping companies or bankruptcies in the African shipping sector. However, this does not mean that maritime insolvency cannot have a strong impact on the African maritime sector. So as I introduced in the first slide, shipping is really and truly a global business, meaning that the insolvency of an Asian shipping company or a European shipping company can still have and will probably have also a strong impact on the African maritime sector. So a couple of questions that may arise in the wake of a maritime insolvency is, first of all, in relation to the ship. So do you still allow a ship in your territorial waters whenever you know that the shipping company is actually bankrupt? So then you're facing the risk that the ship will just lay idle in your territorial waters, not pay its port fees, perhaps pollute the environment, etc., etc. Another problem is stranded containers. That was actually a huge problem during the insolvency of the South Korean shipping company Hanjin a couple of years ago. So what do you do with all these stranded containers in the port? Who will pay for the port fees? Who will transport these containers? So all these kind of questions. Another question relates specifically to the ships registered in Liberia. So do all the creditors have to go to Liberian courts in order to enforce their claims? How do you deregister these ships? All these kind of questions. And then there are numerous other questions, such as the repatriation of seafarers and others. So a vast variety of different challenging questions that may arise in a maritime insolvency, and specifically also even in a continent like Africa, where there are not many shipping companies, but you can see that there might still be a strong impact on the African maritime sectors of other shipping companies in other continents. So in essence, then, focusing on the biggest challenges, the more legal challenges in a maritime insolvency, you see that there are a lot of different conflicting interests in maritime insolvency. So for instance, you have, of course, just like in other insolvencies, you have a lot of different conflicting creditors, conflicting stakeholders. In a maritime insolvency, you have the ship financiers, you have all sorts of smaller maritime service providers, bunker fuel providers, pilots, salvors, seafarers, of course, all these kind of smaller maritime service providers, but also governmental and semi-governmental organizations, such as the ship registry and classification societies. Another conflict in a maritime insolvency is really a conflict of sovereignty. So if you take the example of the insolvency of Hanjin a couple of years ago, insolvency proceedings and other proceedings were opened in no less than 43 different countries. So how do you coordinate all this? How do you deal with the sovereignty of all these different countries, all these different proceedings? Related to that, you also have conflicting norms. So vertically, there are a lot of different levels of regulation that play a role in a maritime insolvency. You have different maritime international conventions, maritime liens and mortgages convention, ship arrest conventions, well, all sorts of maritime conventions. But then you, of course, also have other regional initiatives. You have the UNCITRAL model law and cross-border insolvency. You have domestic maritime laws. So all these different levels of regulation also come into conflict from the moment a shipping company goes insolvent. Very closely connected to that, but then more of a horizontal conflict, is a conflict between different fields of law. So on the one hand, you have insolvency law, and on the other hand, you also have very specific provisions of maritime law that collide during a maritime insolvency. Finally, then, there is also a conflict between the legal reality of a shipping company and the more economic reality of a shipping company. So, well, to elaborate a bit on that, so a shipping company is generally structured as a shipping conglomerate of different group of a group of companies, so an economic group of companies, consisting of different one-ship companies. So sort of special purpose vehicles consisting of only one asset, being one ship. So you see that a maritime insolvency is generally a very complex myriad of all sorts of different conflicting interests. But then, if you look at the core of the legal core of a maritime insolvency, and you compare that to the legal core of cross-border insolvency, then you might also wonder, well, what exactly is the difference between a maritime insolvency and all other cross-border insolvencies? Because also with other cross-border insolvencies, they all have their own special characteristics. They're all very complex. There are different interests, different countries involved. So you might wonder, well, what makes a maritime insolvency so special or so different? So one might say that this is the truly international dimension or the global dimension of a maritime insolvency. But I wouldn't agree with this because, well, cross-border insolvency, the entire purpose of cross-border insolvency is dealing with this kind of international conflicts in insolvency. So I wouldn't say that this is really what distinguishes maritime insolvency from other cross-border insolvencies. Second thing that you could argue is this very specific or special structure of a shipping companies. As I introduced earlier, this big group of companies with all sorts of one-ship companies being part of it. So you could say that this is what distinguishes a shipping company from other companies, but well, the problem of group insolvency has actually been well documented, and actually that's been so well documented that since 2019, the UNCITRAL has published a model law specifically on enterprise group insolvency. So this is a problem that not only plays a role in maritime insolvency, but also plays a role in other cross-border insolvencies. But so what really distinguishes a maritime insolvency from all other cross-border insolvencies is that maritime companies, shipping companies are, or maritime law is really characterized by a number of special maritime law concepts and procedures, which are totally unknown in different fields of law, in other fields of law, and these concepts really conflict with some principles of cross-border insolvency. So, more specifically, what are these specific maritime law concepts and procedures? Well, these concepts and procedures, just like in insolvency law, they regulate debtor-creditor relationships. So, for instance, there are maritime liens for smaller maritime service providers, but you also have ship mortgages, which are quite different from regular mortgages. In civil law countries, ship hypothecs. Closely connected to that is also the procedure of ship arrest. So this is a very specific procedure to efficiently and quickly arrest the ship and release the ship again, and immediately get your get your claim met on the ship itself. But besides that, there are also specific procedures to protect the debtor, such as the limitation of liability procedure and so-called limitation funds. So all these very specific maritime law concepts and procedures collide in a way with the principles of cross-border insolvency law. And it is important to also highlight that these maritime law concepts and procedures are have a very rich and long history. They are accepted and recognized all over the world, and they are very well perceived, or at least tolerated, in the maritime sector. Maritime stakeholders take these procedures and concepts into consideration, and a sort of a balance has been struck between the interest of maritime creditors and debtors by way of these specific procedures. But as I said, well, in recent times, these have been quite disrupted by the introduction of cross-border insolvency instruments. So this was a little bit of context in general on maritime insolvency and on the maritime business, but today I would like to focus mostly on the protection of maritime liens in African countries during cross-border insolvency. And the reason for this is that, well, I think this is really the most peculiar sort of maritime security interest. And as a result, it's also the most challenging to administer maritime liens in a maritime insolvency and in a cross-border insolvency. And most importantly, perhaps, I also think that this protection is most relevant in an African context. But I will explain the reasons for that later. But if I would give a similar presentation on maritime insolvency in, let's say, Greece or Japan, then probably I would focus on ship mortgages. But I think in African context, it's really important to focus more on the protection of maritime liens. So, well, a couple of disclaimers and some expectation management here. So as I already said in the beginning, I will focus mostly on cross-border insolvency. I will also give more of a bird's eye view, a general overview of the regulatory field of maritime insolvency in Africa, rather than really focusing on a specific country. Of course, I will give some illustrations left and right, but it will be more of a general overview. And finally, obviously as well, well, the assessment of the model law will only be in relation to maritime liens and maritime insolvency, and not an assessment of the model law in general. Okay, so turning to maritime liens. So maritime liens are also known as privilèges maritimes, like maritime privileges in civil law countries, but they are well, generally accepted in legislations all over the world, in domestic legislations all over the world, and similarly as well in legislations of African countries. So the goal of maritime liens is to protect claims that are considered crucial for maritime commerce. So I gave a couple of examples here on the slide of claims that are generally granted this maritime lien status. So you see, for example, claims for salvage, claims for seafarers' wages, collision claims, port fees, etc., etc. So this is the goal of maritime liens, protecting claims that are crucial for maritime commerce. But how does this maritime lien protection work then? So I think the two quotes on this slide quite eloquently explain how maritime lien protection works. So the first one is from well, the landmark case on maritime liens from the Privy Council, the Bolt-Buckley, which states that this claim or privilege travels with the thing into whosoever possession it may come. It is inchoate from the moment that the claim or privilege attaches. So this is the most common definition of how maritime lien protection works, but I think that the second quote explains how maritime lien protection works in an even more vivid way, and therefore more in a clearer way. So it says that maritime liens are like a cloud hanging over a ship. It is a black cloud that both the debtor and lien holder can see, but to the innocent purchaser, it is a colorless, odorless, and invisible vapor that only turns into a visible cloud when the lien holder arrests the ship and makes his lien known to the purchaser. So if you look at maritime lien protection in African countries, but also in general, you see that there are 6 ways in which maritime lien protection is granted. So first of all, they arise by operation of law. There are no formalities required. So it is really a secret, invisible cloud that follows the ship wherever it goes. And then maybe focusing on the most important aspect of maritime lien protection, it also has priority ranking over ship mortgages and all other claims. So it really has the highest priority ranking on the ship. However, if you look at certain illustrations of maritime lien legislation in different African countries, in African legislation, then you see that there is quite some difference in the recognition and also in the priority ranking of maritime liens, depending on the applicable domestic law. So if you compare, for example, the Nigerian legislation with the Kenyan legislation, you see that both of them have a quite limited list of maritime liens. Also, the categories quite, they correspond quite. But you still see that there are certain important differences. For instance, the maritime lien for port fees is very high in the ranking in Kenya, while in Nigeria it is quite low, just above the ship mortgage. By contrast, if you then look at the legislation in Côte d'Ivoire, there you see that there is a way more extensive list of maritime liens, and there are even certain maritime liens recognized there that don't even exist in Nigeria or Kenya. For example, the maritime lien for environmental claims, for ship security claims, but also a very considerable claim for shipbuilding and ship repairing claims. So in general, maritime liens are crucial for the smooth operation of maritime business. And especially for African countries, I think it is crucial to highlight that it is important to have a longer list of maritime liens, because in general, countries with a stronger ship owning culture have a more limited list of maritime liens, whereas I see that there are some questions in the chat, sorry, I thought that Hamisi was.
Warren, I was like, time-wise, you need to start. It's interesting, really, but you need to start.
Yes. Okay. Great.
That's really interesting.
I will come to. I will come to my conclusion.
Okay.
So, well, the UNCITRAL model law. So what is the relationship between the UNCITRAL model law and maritime liens? Here you see an overview of the countries that have implemented the model law in African countries. Here you see more specified on well, countries that are considered crucial for maritime commerce in Africa. But if you then look at the administration of maritime liens under the model law, then you see that because of the universalist spirit of the model law, where only one country, well, all the worldwide assets of the shipping companies are administered in one country, that this might actually be detrimental to the protection of maritime liens. So if a foreign lien proceeding is recognized in a certain country, as a result, certain maritime liens that are protected in, let's say, South Africa or Nigeria, if such maritime liens are protected under the domestic laws of Nigeria or South Africa, well, perhaps under the main insolvency proceedings, they will not be recognized, or they will have a different priority ranking. But even if they are recognized, and even if they have the same priority ranking, then they will have different enforcement mechanism. They will just form part of the insolvency estate, rather than them being enforced through the more swift procedures of ship arrest. So in general, in conclusion, I would say that, well, the administration of maritime liens under the UNCITRAL model law can be very detrimental to maritime lien holders, and therefore, as a consequence, would also be detrimental to maritime commerce as a whole. Thank you very much.
Thank you so much, Warren. It's really, I never wanted you to finish because I was on a ride, and this is really a hot topic of interest to me moving forward. But since we're running out of time, may I now invite Julia, the discussant for today, to share her views on the topic of the day, and perhaps open the floor for people to raise their questions. Thank you, Julia. You're welcome.
Thank you so much, Hamish, for having me here. Warren, always nice to hearing you. I know this. Nice to see you as well after a few months not seeing each other, even if virtually. So it was a very nice presentation. Congratulations. So my first question to you is, I actually wrote it down so it'd be easier. So it can be said that, like as you said yourself, that the model law, in particular the EU insolvency law regulation, are quite detrimental to maritime privilege claims or maritime claims in general, in particular. But then if you consider that, especially if you consider like the cabotage law in Nigeria, and there is a strong cabotage law that is modeled by the Jones Act. So even if you put the claims, as you see in your chart, you see that Nigeria focuses a lot on seafarings, like in injuries and so on and so forth. And consider that is an oil field as well. And so we talk about offshore platforms. in the Nigerian waters, and we're talking about vessel assistance in Nigerian waters. So for them, actually makes sense to not sign the model law, don't you think so? And the same goes to Liberia, because as you said yourself, it's like a main register still, especially for oil tankers. Is the third biggest register at the moment. But it is, I think you mentioned at the beginning, all privilege claims, all ship arrests, every single thing needs to be registered in the Nigerian registry because it's the flag of the vessel. So for them, again, especially because it is a register that is considered a flag of convenience because of all the convenience things that give the ship honor in terms of protection, don't you think that for them it makes sense also to not actually implement the model law in order to actually protect their commerce, their own legislation?
Yes, thank you very much, Julia, for being here, and of course as well for the question. It's also always nice to see you. And well, so as regards to your question, first of all, focusing on Nigeria. Well, I'm not really aware of the particular reasons why Nigeria has or has not implemented the model law, but so I can only so I can only guess. But what you're saying makes sense, especially since the cabotage laws of Nigeria actually kind of prove or highlight a more protectionist view in terms of maritime business in Nigeria, which would actually also be sensible in terms of maritime liens. So indeed, well, because of this more protectionist view, I think it really makes sense to not implement the UNCITRAL model law and not give away your socioeconomic priorities in favor of an insolvency procedure somewhere in South Korea or wherever. So I think this really makes sense in terms of well, the Nigerian regulatory environment. As regards to Liberia as well, I think in general, the ship registry, or where the ship is registered, is strongly influenced by ship financiers. So if ship financiers want a ship to be registered in Liberia, they have the reasons to do so, and they don't want this to be overturned at some point by the insolvency of the shipping companies that will point them to a different jurisdiction. So for this reason, I also think that it makes sense that these countries didn't adopt the model law for maritime insolvency specifically, but also in general.
Thank you, Warren. This next question is also to actually, I would like to hear your opinion because it's actually taking the difference of the shipping industry in account. So the shipping industry also, like we talked about stakeholders. So one stakeholders are the protection damage clubs. Usually they pay for third parties damage and so on. So if you think about the protection damage clubs, they do pay for a lot of like the liens that is like in essence like the first liens in all the countries that you quoted. So if you think about this, take this under consideration, it doesn't change much. It doesn't change much if you actually adopt the model law, if you do have protection damage clubs. So what do you think in this regard? Because this is another difference that I think we take into account and talk about insolvency. As I said, the one sister, one ship company. So group of companies are common, but then we also have that Hanjin is an example of like cross-border insolvency in the shipping industry, Nevertheless, we're talking about like a really big shipping like a company. Like there was the seventh largest container company in the world. But then we have the smallest one. There are a lot of the times the owner, you cannot even find the owner. Like they open also like other companies. So there is this difficulty, the difficulty of finding the owner and the owner of the vessels. So, what is your opinion about in these regards, like about this difference in shipping companies and in companies in general?
That's a very valid question, and well, a very valid remark, because you could think, well, if maritime liens are usually paid out by the insurer of the shipping company, then this actually doesn't really play a role within the insolvency proceedings at all. This is a separate proceeding between the P&I club and the maritime lien holder, right? This is what you were kind of mentioning, right? Yes. So I think this is a very valid remark. Although you must also well, it's also important to highlight that often in the insurance policies there are these ipso facto clauses stating that, well, at the moment that the shipping company turns insolvent, that then the insurance cover basically stops. You know, and well, these kind of ipso facto clauses are not recognized in all or are not allowed in all jurisdictions. But then still, I think this is something that you should take into consideration as well. So you can't really say, in general, I would say that, well, because P&I clubs generally pay out the maritime liens, that therefore, well, maritime liens don't play a role at all in insolvency. I think it really strongly depends on whether or not there is an ipso facto clause, and secondly as well, whether or not it is allowed to have such an ipso facto clause at all.
Thank you, Oren. Thanks for the lovely presentation and the remarks as well. And it's a very interesting topic, of course. I find it interesting, you know that. And especially because of the substantial difference in the ship industry, in the ship company, in the company in general. Apart from, in a way, being more protective in terms of, like, we talk about international companies, sometimes we do have like a case of repatriations of employees, but and in terms of shipping industry, because it has happened so many times, like there are a lot of conventions protecting as well. So it was great. Thank you so much. And I think I should open the floor for other questions, right? I could go and keep asking you, but I think I should allow others to ask you. Thank you so much, Warren.
Thanks, Julia.
Thank you so much, Julia. It's really good targeted topics that invoked a good response from Warren. Now, I personally have a question, but before I ask my own question, I would like to invite any other colleagues who has a question, and it would also be interesting to get them involved as well. Anyone with a question, please. Yeah, Bolanle, you have your hand up.
Yes, hi Warren. Thank you very much. Very interesting presentation. I would not say that I have ever looked into maritime insolvency, but it sounds a really intriguing area of law. I was just, so about the Nigerian cross-border law, the reasons, well, sadly, Chief isn't here. His firm was involved in some of the discussions around the reform, or at least they contributed to the reform of the insolvency law in 2020 in Nigeria. And he was the past head of the Business Recovery and Insolvency Practitioners Association of Nigeria. And so he knows some of the backstory. I know that at the time, I'm not sure what Chief's position is today, but I know that in the past, he had been very keen on having the cross-border insolvency introduced into Nigeria. I know that now that he's finishing his PhD, he has perhaps some slightly different thoughts as to cross-border insolvency law and how that might work in Nigeria. So it would have been great. He did register, but he's not here today. But it is the case that we still don't have that in Nigeria at the moment. And I don't know that it is particularly a bad thing. But of course, it would be helpful if we had something to facilitate cross-border issues. I was just wondering, looking at the context that you set out, in which jurisdictions would ship owners prefer to open up their, would ship owners prefer that insolvency proceedings be opened up, and how would such a jurisdiction deal with securities arising by virtue of law?
Thank you very much for this comment and question, Bolande. I'm very curious as well to hear why exactly at the end of the day Nigeria decided not to adopt the UNCITRAL model law. As regards to your question as to where ship owners would prefer to initiate insolvency proceedings, right? Well, I think in general, ship owners prefer to initiate the insolvency proceedings in a country that has a limited list of maritime liens. So in countries that are well, stronger ship owning countries, but also, well, for instance, Nigeria also has a quite limited list of maritime liens over ship mortgages. So I think this would also be a favorable jurisdiction to open insolvency proceedings. But I think that from an African perspective, you should rather look at, well, where can maritime service providers be protected the best? You know, because since African countries generally for now don't really have this strong ship owning culture, they need to find other ways in order to make trading with Africa more attractive. You know, and you can do so by actually incentivizing the maritime service providers by actually protecting them with maritime liens. So I would say that it is more important to look at these countries where you can still enforce and secure your maritime lien, even if there are insolvency proceedings in another country. So therefore, I would say that it's better to focus on these African countries that have perhaps a more territorialist view in terms of cross-border insolvency, or in terms of maritime lien protection at least. And well, take this as an example rather than looking at which country can be the best insolvency jurisdiction in a way. I think it's more important to look at in which country can you protect the maritime service providers the best.
Well, thank you. That's a very interesting answer. I suppose, follow-up to that will then be that if Africa decided to be territorialist in the way that they approach insolvency law, what are the chances that Africa can develop an industry in which we have maritime insolvencies, in which we attract maritime insolvencies into Africa? Now, if the AfCFTA came into effect and trade grew, you know, I'm trying to think of what the implications would be if everyone decided to protect. I'm not saying that that's a reason, you know, in another world, I would come here to tell you how important it is to create the to protect the weaker stakeholders. But, you know, we're also looking at the ability to attract business into our region. And it's just how to strike that balance that I'm trying to reflect on here.
Yeah, I think it is a very it's always a question. It's always a very delicate balance of different interests that you have to take into consideration. So on the one hand, I'm also not really a proponent of absolute territorialism, not even in terms of maritime insolvency. I think it would be, for example, an idea if African countries, whenever they implement or whenever they decide to enact the UNCITRAL model law, that in their domestic enactment that they provide for an exception for maritime liens, for instance. And I think, well, in order to attract maritime business to Africa, I think maritime lien protection there is really crucial and is really a first step, because how are you going to attract maritime business if you don't protect your own maritime service providers? So if you don't protect your own ports, your own seafarers, your salvors, your pilots in your ports, how are you going to attract shipping from other continents? So I think this is a first premise in order to attract shipping into Africa, and then in order to maybe develop a more ship owning culture, the first step is to protect the maritime service provisions and make sure that, well, the services are satisfying in a way. And I think you can do so by protecting maritime liens specifically.
Okay, we have Uche now. Thank you, Bolanle, and thank you, Aaron. We have Uche now with a question, then one more, and then we can conclude our session. So Uche now, welcome.
Yes, thank you very much. Glad to be here. Aaron, thanks for a very nice presentation. I wanted to ask, given the fact that when the model law was being adopted, maritime lawyers were not consulted, and so we had this issue with respect to maritime lien and some peculiar maritime security mechanisms. Would it be your position that, would it then be your position that for African countries, especially for the ones, few ones you have examined, that do you see a situation where maritime lawyers of every country should be consulted before each country decides to adopt the model law? Because if that is not done, it's going to have friction actually between the insolvency practitioners on the one hand and the maritime law practitioners on the other hand, because maritime lawyers would always stick to those security mechanisms which predates insolvency traditional protection mechanisms. So would you subscribe to this position?
Yes, thank you very much, Uchenna, and it's nice to see you too here. Yeah, thank you very much. This is a very interesting question, and of course there is there would be a friction perhaps between insolvency lawyers on the one hand and maritime lawyers on the other hand. But I think if you look at examples of enactments of domestic enactments of the model law in different countries all over the world, I think one of the biggest problems, especially in relation to my research, is that maritime community has not been consulted at all. So there has not been any consideration of what the impact might be of these kind of instruments on maritime insolvency. And you even see this in certain countries that really have such a strong shipping history and ship owning culture. For instance, in Greece and in the United States, both of these countries have adopted the model law with a very universalist approach without taking into consideration maritime protection at all. While you might think, well, with the rich history, with the rich shipping history of Greece and the United States both, that yeah, this would have been taken into consideration. And if you look at the United States in particular, you could see that during the insolvency of Hanjin, so a couple of years ago, that then ship arrests were actually stayed in favor of the insolvency proceedings in South Korea, even in the United States. So this is just to demonstrate how little consideration has been given to maritime stakeholders at all in this cross-border insolvency legislation. So I think a way forward would be for countries who are new to adopting the model law. A better way would be to at least start by consulting some maritime lawyers.
Thank you very much.
Thank you very much, Uchenna. My question, I think, has been answered because I was going to ask whether the model law is really fit for Africa and whether universalism or territorialism would be a better fit for Africa. But I think in your answer to Bolanle, you kind of touched on that. But just to draw more light onto that, do you think that if, because I come from East Africa, where we are a landlocked country, we rely on Mombasa Port. And in your earlier discussion, you didn't even mention Mombasa Port as one of the largest ports in the region, in Africa. And we've grown up thinking, because in my family, when my uncle was always waiting for his shipment to arrive, oh, I have to ring Mombasa. I have to hear from Mombasa, because the companies have to go to Mombasa from wherever goods arrive, and then they have to take them on road to Uganda, Congo, and all that. So do you think that as the world is going into global commerce, if we say we would favor territorialism, do you think Africa should have its own special model on maritime insolvency? Would that really benefit Africa, rather than trying to have a universal approach, which wouldn't really benefit Africa? A small person trading like in Uganda or in Tanzania being tied to a universal model, which would not really be fit for purpose. So do you think that would be a better approach for Africa moving forward?
Thank you very much, Hamizi. I was actually also pretty surprised when I was looking into the statistics given by UNCTAD, but also by a couple of other organizations that didn't mention the Mombasa port as one of the largest ports in Africa. Well, some statistics mention them as one of the largest ports in Africa, but not as one of the best connected ports of Africa. But then in response to your question regarding whether African countries should have a sort of a regional or a continental specific approach on maritime insolvency, I don't think that this would be a feasible solution, especially taking into consideration that shipping is a very, it's really a global business, so you can't really see the maritime business in Africa in a vacuum. And I know that I sound a bit contradictory here, because on the one hand I say that shipping is a very global business, but on the other hand I also say that, well, we should have certain territorial protection mechanisms for specific maritime liens, but this is because these maritime service providers are strongly dependent on the national country. So I've looked into a couple of different alternatives for the current state of law. So on the one hand, I think absolute territorialism is just infeasible, so this can be set aside. Also absolute universalism as well, but then in between that there are a lot of different options. So I think the most realistic one is still within the model law. It's still within the model law, but with certain exceptions for maritime claims. If you look at international initiatives, so more international hard law conventions on maritime security interests, like for example, Maritime Liens and Mortgages Convention, you see that all these initiatives have been very laudable, but because of such a variety of different interests depending on a specific country, they have not been very successful. There has been 3 or 4 initiatives in that regard. There has also been the Cape Town Convention, which attempted to regulate or to provide a framework for all maritime security interests, so ship mortgages, maritime liens, etc. But while there has been a very successful protocol on this Cape Town Convention for security interests on aircrafts, there has never been such a protocol. There has never been a consensus on such a protocol for maritime security interests. So I don't think that international initiatives, I think there is too much of a variety for international initiatives to be a realistic alternative. I still think that within the model law, you should find a way to include a more territorialist approach within this broader universalist spectrum of the model law.
All right, thank you very much. And unless we have another question, I'd like to...
Let me see, I think Julia had a hand up, but she then put it down, so I'm not sure if she had a comment.
Okay, Julia, please.
I do, but I didn't want to stretch it up a bit because I would like to hear Warren's. It's just because Nigeria is a country that I have researched the most, the only country that I have researched in Africa, in fact. So I think the shipping industry, so the shipping industry in Nigeria, the offshore industry is quite strong. And the MASA, that is the regulatory body in Nigeria, it's quite strong in terms of political powers there. And so I do believe that they, in the sense of the ship industry, they do try to protect their employment, the whole thing to be Nigerian, so to protect the country itself. Of course, there is a lawful law because for instance, it says that the ship must be built in Nigeria. But again, Nigeria doesn't have any shipbuilding anywhere to build ships and so on. But it is in this sense, it protects the country as well as protecting the industry, and it doesn't change anything but it really does protect the country itself. So it's a very, very territorialist approach, even protectionism in this sense. But then again, my question is because it does follow the Jones Act in the US, and that's as Warren said, well, Greece has signed the model law, like has implemented the model law, and the same goes to the USA. But then, Warren, don't you think that if you think about it, it's also because it's good for the ship owners, and the ship owners are there. So the ship owners are in the US and the ship owners are in Greece. So for them, it actually makes sense to actually ratify, to implement the model law. So if you consider these, take these under consideration, it shouldn't be surprised. I would like to hear your thoughts of surprise, I mean.
Mm-hmm. No, I agree that it makes more sense for Greece and the United States, for instance, to implement the model law because they have such a strong ship owning culture, meaning that most probably the center of main interest of the shipping company will be located in Greece or in the United States. So, well, all the assets will be administered under the Greek or American insolvency proceedings. But still, well, the Hanjin example has proven that this is not always the case, and that ships had ship arrest proceedings had to be stayed in the United States in favor of the insolvency proceedings in Korea. So I think even in ship owning, in countries with a very strong ship owning culture, even there, they should be aware that, well, the center of main interest will not always be located in your jurisdiction. So you should include certain exceptions within the model law, stating that, well, maritime liens should still follow a territorialist approach. So I think coming back then to African countries, I think if in the upcoming years, the African fleet increases, and perhaps also shipyards are, there are more shipyards on the continent, that even in that case, while enacting the model law, you should still have this disclaimer for maritime liens there, because, well, it's always about a balance. You know, you're not always like a 100% ship owning countries. You also need to protect the maritime service provisions in your country. So yeah, it's all about striking the right balance, I think.
Thank you.
Okay, thank you very much, Julia. Unless anyone has another question, I would like to thank Warren for such a wonderful presentation and Julia for the insights shared. And we just wish you a really happy end of the year, a happy Christmas, and do take some rest because the new year will be really challenging. We'll have so many presentations, and if the conference also comes to take effect, we will be traveling, and so it will be really a good year ahead. So enjoy the break, and we will be in touch with the plan for the new year. Thank you very much. And